that Wallace had suffered a life-threatening heart incident because of the stress caused by attempts to serve the Rule 202 petition. The It Ends With Us saga is not for the faint of heart.
We now have multiple people who have been hospitalized due to the stress of daring to work with this woman.
Blake Lively just got canceled harder than ever after one of the men she sued ended up having a heart attack. Turns out when you throw around shady lawsuits like confetti, someone's bound to end up in the ER.
I feel sympathy. My personal view is I feel sympathy for Jed Wallace on what I know thus far.
Honestly, being anywhere near Blake these days feels like a full-body hazard warning for both your career and your life.
Jed Wallace. He, according to the potty-trained princess, is a key player in the retaliation campaign against her.
Jed Wallace isn't just another name floating around in this controversy. His role cuts right to the heart of why Blake Lively's legal strategy is falling apart. Wallace was a former PR executive tied closely to Wayfarer Studios, the company co-founded by Justin Baldoni.
Team Baldoni has repeatedly denied any retaliation, any smear campaign, and a perceived astroturfing is all organic, truly, because people can make up their own minds based on everything that the plantation princess has said and done.
But more importantly, he was someone with a direct line into everything that went wrong behind the scenes at Jones Works, the PR firm at the center of this entire mess.
In Blake Lively's initial lawsuit, she did not include Jed Wallace. However, in the amended complaint, he was added alongside Baldoni.
What made Wallace such a threat to Blake and her team wasn't just his proximity to the drama. It was that he knew the timeline. He knew when things started to go wrong, who said what behind the scenes, and how much of Blake's public statements didn't line up with the reality of what was happening at Wayfarer.
The soon-to-be 50-year-old alleges that Jed Wallace, who lives and works in Texas, is the person most responsible for the astroturfing against her, which has hurt not just the burgeoning baker, but also Blakey Crocker's family and her businesses.
Wallace wasn't repeating rumors. He had direct knowledge of emails, meetings, and internal decisions. Blake's team quickly realized how dangerous that was. Instead of facing the facts laid out by Wallace, they tried to paint him as a rogue actor.
Jed Wallace filed a lawsuit in Texas against her first. And now the Queen of Hearsay has filed a motion in Texas to be dismissed from Jed Wallace's lawsuit.
They suggested he wasn't trustworthy, that he was acting out of revenge, or that he had some hidden agenda. But that strategy didn't hold up. Wallace's employment records, the dates of his contracts, and the projects he worked on were all documented. His credibility wasn't easy to shake.
Jed Wallace evaded and obstructed Miss Lively's persistent efforts to seek information from him before filing this lawsuit in anticipation of becoming a party in the New York litigation.
And that's where the real panic started. If Wallace's version of events held up, Blake wouldn't just lose control of the narrative. She could lose everything she was fighting to protect.
On January 23rd, Khaleesi, in her own mind, after trying to serve Wallace at his gated property, her process server received a text message from an associate of his lawyer, Brian Friedman.
Her entire claim of being the victim of a smear campaign would collapse. Wallace's credibility was strong enough that simply attacking him wasn't an option. It would require dismantling actual evidence, and Blake's team wasn't prepared for that. Things got even worse when Jed Wallace filed a formal declaration under penalty of perjury.
Jed Wallace himself is suing Blake Lively for defamation.
In California, that's serious. Under Code of Civil Procedure Section 2015.5, a declaration under penalty of perjury carries the same legal weight as testifying in court. If Wallace lied in his statement, he could face criminal charges, including prison time.
Quote, Wallace's counsel also indicated that Wallace had suffered a life-threatening heart incident because of the stress caused by attempts to serve the Rule 202 petition.
That's a massive risk for anyone to take, especially someone who was never directly suing or being sued in the main case. Wallace had nothing to gain by lying, and everything to lose.
And remember, this is how the Z-list actress operates.
His declaration was just 2 pages long, but in those 2 pages, he dropped a legal bombshell. He described how Jones Works, the PR firm working with Blake Lively, manipulated the public relations timeline to favor Blake's version of events.
Quote, after engaging in a retaliatory social media campaign against Miss Lively, plaintiffs now seek to drag her into a foreign court that lacks jurisdiction in an attempt to further punish her for privileged communication.
Even more damaging, Wallace said he faced retaliation and intimidation after he refused to participate in the cover-up. According to him, the moment he made it clear he wouldn't lie to protect Blake or Jones Works, he became a target. His work opportunities dried up.
Poor Jed Wallace. He's lucky to be alive. The rest of her motion is pretty standard stuff. She made no specific defamatory statements against Jed Wallace, blah, blah, blah.
His name was quietly blacklisted in circles where Blake's influence was strong. And all of it happened after he pushed back against the false narratives being built by Blake's team. 2 pages might not sound like much, but the legal impact of Wallace's declaration was enormous.
Last night in Texas federal court, Blake Lively filed 802 pages in her attempt to dismiss Jed Wallace's lawsuit.
He didn't need hundreds of pages filled with gossip or vague allegations. What he provided was clean, direct, and legally devastating. His statement introduced 2 serious legal theories into the case: witness tampering and wrongful retaliation.
If you try to sue somebody for something and you make allegations or claims about them in a court filing under penalty of perjury, it's very difficult to then use those claims as grounds for a defamation claim.
Witness tampering means any effort to intimidate, threaten, or coerce someone into changing or withholding their truthful testimony. Wallace's claims about retaliation suggested that Blake's team tried to pressure him to stay silent or change his story.
So frankly, off the bat, I think Jed Wallace has an extremely uphill battle.
If proven, that wouldn't just hurt Blake's credibility, it could trigger a criminal investigation.
Blake Lively filed a complaint of employment discrimination. Now, this was like a precursor lawsuit.
Wrongful retaliation is another huge problem. Under California Labor Code, retaliation is clearly defined. It's illegal for an employer, or someone acting on their behalf, to retaliate against a person for disclosing information the employee reasonably believes violates state or federal laws.
Because Blake mentioned Jed Wallace in that first CRD complaint, the one that wasn't really a lawsuit, but then whenever she copy and pasted a whole bunch of stuff into that real lawsuit, she did not copy and paste Jed Wallace or street relations.
Wallace's declaration fits into protected whistleblowing activities. He reported what he believed were unlawful practices, including intimidation and PR fraud. The law specifically protects whistleblowers from exactly the kind of retaliation that Blake's lawsuit appears to represent.
Blake Lively messed over her own self by even so much as doing these interviews that she did, wearing the clothes that she did. Basically, she created this problem for her own self.
Breaking down Blake's real motive reveals a more disturbing picture. Her legal move against Wallace wasn't just about defending her reputation. It was about silencing a witness before trial discovery could expose even more damaging details.
I believe Blake Lively absolutely did a lot of the stuff she's accused of doing. I do not like how she acts. I do not like how she behaves. I don't like how she treats people. And frankly, just as a side, I don't really like the clothes she picked out for that character. They was ugly. They were ugly clothes, okay?
Discovery, the formal legal process where both sides gather evidence, was about to begin. Once Wallace was locked into defending himself in a new lawsuit, it complicated his ability to continue helping Baldoni's and Ailes' cases against Jones Works, and by extension, Blake Lively.
Blake Lively filed a complaint. It went on to allege that his conduct included harassment, retaliation, failure to investigate, prevent, and/or remedy harassment, aiding and abetting harassment, and retaliation.
There's heavy irony in Blake's strategy. Her legal complaint mirrored exactly what typical corporate employers do when whistleblowers come forward: slap them with lawsuits to scare them, discredit them, and drain them financially. It's a textbook retaliation play, usually carried out by large companies trying to suppress damaging disclosures. In Blake's case, it looked desperate.
It basically looked like he got sued for harassment. He's saying, I did not harass her. I did not retaliate against her. I never entered into any contracts with Blake Lively, so I had no contractual obligation toward her.
The most devastating part for Blake? Filing a lawsuit against Wallace only made her look more guilty, not less. It validated Wallace's original claims about retaliation.
Blake Lively put Jed Wallace and Street Relations Inc. in the not really a lawsuit complaint. But when she went to file the real lawsuit, she did not put his name in it.
In legal terms, this move is called retaliatory litigation, filing lawsuits intended to punish someone for exercising their protected rights. Courts take this extremely seriously because it undermines the entire judicial process. Instead of shutting Wallace down, Blake's lawsuit risked opening her up to anti-SLAPP motions under California law.
Lively's lawyers are saying that the mere fact that you're part of a conspiracy is enough for us to drag you into New York, even though you otherwise would not fit under the long-arm statute.
Anti-SLAPP statutes, strategic lawsuit against public participation, exist to protect individuals from retaliatory lawsuits when they're speaking out about matters of public interest. Wallace's statement involved public figures, workplace misconduct, and legal manipulation, all protected speech.
She didn't exhaust her administrative remedies with the EEOC.
And so if she did not get a right to sue under EEOC, even if those two claims go away, she still has all the FEHA claims under California law.
If Wallace's attorneys filed an anti-SLAPP motion and won, Blake could be forced to pay Wallace's legal fees and face additional sanctions. The entire sequence of events painted a clear picture. Wallace wasn't the one retaliating.
I feel that he's been dragged into this. I think he's trying to run a business in Texas, and he's going to have to go to New York and be dragged to New York. If they get him up there, it's going to make his life miserable.
Blake's legal team was scrambling to silence a key witness before his testimony did even more damage. And the harder they pushed, the more it looked like Wallace's original claims about intimidation and retaliation were absolutely true. Beyond the personal attack on Wallace, his testimony blew open a much bigger scandal: Stephanie Jones' toxic workplace at Jones Works. For years, Jones Works had operated with a polished, celebrity-friendly exterior.
If you're a judge or a clerk that has to review this, you're literally not going to read this.
No.
You're simply just going to throw it to the side because you have so many cases you're working on. And so you have to be able to, look, all of this could be very substantive. All of this could be very good information. It's just presented in a way, in my opinion, I think it could be presented much better.
But Wallace's sworn statement confirmed what former employees like Jennifer Ale and others alleged in separate lawsuits. The reality inside Jones Works was anything but glamorous. Wallace's testimony lined up directly with the allegations in Justin Baldoni's legal filings and Jennifer Ale's wrongful termination lawsuit. Both suits accused Jones Works of fostering a toxic environment, breaching contracts, and intimidating employees.
Lively is trying to say that a substantial part of the events giving rise to the underlying tort, which is false light, intentional infliction of emotional distress, and all that, took place in New York.
Wallace's declaration provided the missing link. He wasn't just describing vague, toxic behavior. He specifically pointed to illegal practices, including pressuring employees to manipulate media narratives and actively suppress negative coverage of clients, especially Blake Lively and Ryan Reynolds. The pressure tactics described by Wallace were severe. Employees were allegedly coached on how to steer journalists away from unflattering stories about Blake and Ryan. If negative coverage couldn't be stopped, Jones Works allegedly used intimidation tactics against media outlets, threatening loss of access to celebrity interviews or exclusive scoops if they didn't back off.
which Miss Lively and others discussed Mr. Baldoni and Mr. Heath's misconduct. So that was the 17 points that they went over. That was in 2023.
Was Jed Wallace even on the scene?
No.
Internal communications exposed by Wallace detailed even more disturbing practices. According to him, Stephanie Jones herself allegedly coached Blake on how to spin allegations in the media. This wasn't just about protecting Blake's brand. It was about actively shaping a false narrative that made Blake appear as the wronged party, even when evidence pointed the other way.
Jed Wallace online, I don't remember seeing it there.
They're saying it's, obviously, it's in their four corners of their document, their amended complaint at paragraph 217 and 218.
Yeah, and I looked at those. I have the complaint in front of me that Lively filed, the amended complaint. And here's what's interesting about 218. It starts with, on information and belief, Mr. Wallace specializes in,
right,
et cetera, et cetera.
Right.
Wallace's testimony destroyed any chance Blake had of pleading ignorance. If Jones Works had been operating on its own, Blake might have been able to claim she didn't know what was happening. But Wallace's statement indicated Blake was directly coached on what to say, how to say it, and how to frame her legal battle with Baldoni and Wayfarer Studios.
It was confusing to me too, because it seems like everybody's kind of pointing in that direction, trying to figure out what law we want to apply. And really what they're doing is they're using the law or the arguments that best favor them in that moment.
In California, willful ignorance isn't a defense. If Blake's team actively participates in shaping false narratives with knowledge of the real facts, it opens the door to charges of conspiracy, defamation, and more civil liabilities. Wallace's declaration, though only 2 pages, dismantled any plausible deniability Blake could have maintained. Under California law, retaliation against a witness who has provided a sworn statement is a serious offense. Wallace wasn't vague in his wording. He accused parties linked to Blake Lively of engaging in intimidation tactics after he refused to lie about what he witnessed.
The claim against Jed Wallace is that he aided and abetted in violating FEHA, which you can do. So a non-employer can actually be liable under FEHA if they aid and abet somebody else, an employer, in harassing somebody.
Because his testimony was filed under penalty of perjury, meaning lying would itself be a crime under California Code of Civil Procedure, FAR 2015.5. Any retaliatory behavior following that filing could be seen as obstruction of justice, a charge that carries criminal penalties under both state and federal law. Beyond the criminal exposure, Wallace's allegations made Blake's own employment contracts vulnerable. Most employment in California is at will, but any proven retaliation against an employee or contractor who reports unlawful conduct voids standard protections employers have. If Wallace's testimony about retaliation holds up, it could open the door for the entire network tied to Blake, including Jones Works, to face contract voidability claims. This means former employees and contractors could claim their non-disclosure agreements, employment clauses, and confidentiality contracts are invalid, giving them legal freedom to disclose even more damaging information without fear of breach of contract lawsuits.
So a non-employer can actually be liable under FEHA if they aid and abet somebody else, an employer, in harassing somebody. So they're saying here that first, that Ms. Lively has not adequately alleged the knowledge element of the claim and against Jed Wallace.
Wallace didn't just stop at basic retaliation claims. Buried in his statement were hints at a larger conspiracy, that Blake's team, in coordination with Jones Works, interfered with witnesses involved in the lawsuits against Jones and Wayfarer Studios. In legal terms, that's witness tampering. It's illegal to knowingly and maliciously attempt to prevent or dissuade a witness from attending or testifying truthfully in any legal proceeding.
So Jed Wallace in Texas would have to know whatever conduct he was conspiring about. He would have to know that it took place. He would have to understand what FEHA was.
And that it violated FEHA to do that.
Okay.
So, because you can't know that you're violating FEHA.
An overlooked but outrageous detail, because Wallace's claims involve potentially tampered communications across state lines. Federal agencies like the FBI could get involved independently of any civil actions. Even if Blake settled her civil issues, federal investigators wouldn't be obligated to stop looking into tampering allegations, and federal obstruction of justice charges carry prison terms of up to 20 years under U.S. sentencing guidelines. Wallace's 2-page document wasn't just an inconvenience for Blake Lively. It was a legal minefield that could trigger cascading lawsuits, contract voids, civil penalties, and even criminal investigations, all from a man who wasn't even part of the main lawsuits filed by Justin Baldoni or Jennifer Ale.
Because they don't want to lose the point they're trying to make in this word salad here. This is a giant word salad.
Right.
We're not sure what we should be reading. There's paragraph signs, there's numbers, there's capitals, there's block text is fully justified. This is really hard to take in. And by the way,
As Wallace's testimony unraveled, another pillar of Blake's legal defense crumbled, the so-called smear campaign narrative her team had carefully built. Blake had originally claimed that Wayfarer Studios, and specifically Justin Baldoni, had orchestrated a coordinated campaign to damage her reputation. But Wallace's affidavit torched that storyline beyond repair. In his sworn statement, Wallace confirmed that JonesWorks actively monitored press coverage about Blake and manipulated media narratives behind the scenes. This wasn't speculation.
we hear about from witnesses in deposition, and that's sworn testimony that they have to tell the truth. We may not be able to see those in this case right away. And then we hear from them at trial.
Wallace stated he personally witnessed JonesWorks employees flagging, altering, and sometimes even pulling articles that cast Blake in a negative light. This systematic manipulation made it impossible for Blake to maintain the illusion that she was a passive victim of malicious external forces.
Court has personal jurisdiction over you. You then have to participate in that legal process, and the court has a right to even issue orders and ultimately a judgment against you.
Because you've availed yourself of the state, therefore the courts.
More damning was the fact that Wallace himself had no direct stake in Wayfarer's lawsuits. He wasn't suing anyone. He wasn't employed by Wayfarer Studios. His only involvement was ethical. He filed his declaration because he believed what he saw was illegal and immoral. That independence made his statement far more credible in court. He had nothing to gain by backing Baldoni or Ale, and everything to lose if Blake's retaliation escalated.
The state of California has jurisdiction over you because you're a California resident. But is venue proper in San Diego County or Los Angeles County or San Francisco County? Well, that depends. It depends on where the action took place. It depends on the convenience of the parties. There's a number of different factors that go into that.
Wallace's affidavit timeline also intersected with suppressed media stories, including journalist Kirsty Flah's controversial resurfaced interview with Blake Lively. Flea's content, which portrayed Blake in an unflattering but neutral light, was allegedly buried through pressure tactics orchestrated by JonesWorks. Wallace's testimony about press manipulation directly supported Flea's claims that there was an organized effort to control the narrative around Blake during key phases of the lawsuit battles.
Can make a decision that falls squarely within the law and applies it to the facts of that case, and they can feel good about it. I think they're going to do it. And I think if Judge Lyman is putting his...
The most chilling realization was simple. Blake's entire case against Baldoni depended on portraying witnesses like Wallace as vengeful, disgruntled, or out for revenge. But Wallace's statement didn't fit that pattern. There was no evidence he harbored any personal grudge. His declaration didn't attack Blake's character with insults or accusations about her personal life. It stuck strictly to professional misconduct, what he observed in emails, phone calls, and workplace meetings.
You got to have a little sympathy for Wallace based on what has been said. Of course, you can't come out and say, yeah, I'm considering extrinsic evidence at the 12B6 phase, but you do feel bad for this guy.
And in the absence of a personal vendetta, Blake's legal team had no credible explanation for why a former JonesWorks insider, with no financial stake and enormous legal risk, would voluntarily expose himself to litigation just to smear her. Wallace's existence as a neutral third party shattered the foundation Blake had built her entire defense on.
I don't want to harm Jed Wallace, but on the other hand, I think it's just going to make everything easier to move forward, to keep it all together. The judge could view it that way too.
Blake Lively's decision to sue Jed Wallace might end up being the worst legal move of her entire career. In California, filing a lawsuit against someone who speaks out on matters of public interest, like workplace misconduct, PR manipulation, or retaliation, immediately triggers protections under the anti-SLAPP statute. California's anti-SLAPP law, set under Code of Civil Procedure, is designed to stop powerful individuals from using lawsuits to intimidate or silence critics.
Some insider is saying that Blake Lively's lawyers hate her and hate Ryan Reynolds. They don't want to represent him and they hate their lives.
If Wallace invokes anti-SLAPP protections, Blake's lawsuit could be thrown out at an early stage without ever reaching a jury. Worse, California law mandates that if a defendant successfully wins an anti-SLAPP motion, the person who filed the lawsuit, in this case, Blake Lively, must pay all of the defendant's legal fees.
We think Brian Friedman is a fantastic lawyer, and we like Brian Friedman. We have nothing bad to say about him. But, he's like any other lawyer. He's working hard on this case. I don't think he's a master manipulator behind the scenes saying, well, they're going to do this, and then I'm going to do this, and then they're going to do this. And he's got it all mapped out. I think he's doing what good lawyers do every time an issue comes up.
Given the high-profile nature of the case and the attorneys involved, Wallace's fees could easily climb into the hundreds of thousands of dollars. And that's just the financial side. Filing a retaliatory lawsuit against a whistleblower in California doesn't only trigger anti-SLAPP consequences. If Wallace can prove that Blake's lawsuit was filed purely because he spoke up about illegal or unethical behavior, he can sue her for double damages under California labor codes.
Here they're alleging Justin made some sort of comments about his genitalia, which, what the fuck does that have to do with jurisdictional issues in this Texas lawsuit against Jed Wallace? Nothing! Not only that, but it's almost certainly untrue, because she appears to have, based on evidence, actual evidence, fabricated or exaggerated every single one of her claims.
That means whatever financial damage he proves, lost job opportunities, emotional distress, reputational harm, could be multiplied automatically. A normal retaliation case could cost a celebrity millions, but with double damages, it becomes even more catastrophic.
People just don't like you. Why? Because you do shit like this. All of this just to try to get his case dismissed or moved to New York court so that all donut shops in Texas can be marked safe.
The legal nightmare is just one part of the disaster. The bigger problem is the optics. Hollywood is already extremely sensitive about retaliation against whistleblowers, especially after the Me Too movement reshaped public perception of silence and complicity.
Again, Jed Wallace, never on the set of the film. Never met Blake Lively. Still hasn't met Blake Lively. When I said that line, this case is a sham, people thought that I was kidding because sometimes I like to be dramatic when I'm reading these filings. No, that's word for word what they wrote here.
If Blake Lively is seen as using her wealth and influence to punish a former PR insider for telling the truth, she risks alienating the very industry that once protected her image. Powerful agencies, PR firms, and industry insiders who once lined up to work with her might quietly pull back, unwilling to get caught up in the fallout.
And in Wallace's case, not even work with her. Barely even work adjacent to with her. They have never met. He was never on the film set. And here's where they came right out of the gate saying, this case is a sham.
There's already visible tension. Independent journalists like Kirsty Flaw have pointed to suspicious efforts to bury interviews and articles about Blake during this period. Wallace's testimony confirming these suppression tactics adds weight to those claims. If more evidence comes out during Wallace's defense, emails, call logs, memos showing coordination between Blake's camp and Jones' works, the backlash will intensify.
So we now have multiple people who supposedly ran an untraceable smear campaign against you. A smear campaign so untraceable that you had 800 plus pages to outline your claims of it to the courts in Texas.
The irony is brutal. In trying to silence Jed Wallace, Blake might accidentally expose even deeper levels of PR manipulation, witness intimidation, and internal misconduct. By suing Wallace, she invites discovery, meaning Wallace's attorneys would have the right to subpoena internal communications, demand depositions, and expose conversations Blake likely never intended to see the light of day. Instead of containing the damage, Blake's lawsuit could blast the entire scandal wide open, dragging in new witnesses, journalists, and possibly even federal investigators if the tampering allegations stick. What began as an attempt to bury a 2-page declaration might become a full-blown public trial of Blake's behind-the-scenes empire. One that Hollywood, and the public may not easily forgive. So now tell me, what do you think about Blake's lawsuit against Jed Wallace? Smart move or total disaster? Let me know in the comments.